Good afternoon. Hello, hello. So it's another Friday. A little chilly today, but I appreciate you being here to learn about ethics and what is going on out there with our situation. So today we have two articles. I am combining two articles of the code because they have pretty much, they follow each other and are related to the same topic. So, as I have stated before, the Code of Ethics spells out the responsibilities that we have as realtors. And it means that also everyone who is a realtor has voluntarily agreed to abide by the Code of Ethics based on professionalism and protection of the public. The two articles today very clearly specify and explain how our protection and disclosures to the public pertain to our obligation. And when we are not following our obligation, the code of ethics we can be subjected to disciplinary actions and sanctions when we are not following the code. The articles we're going to talk about today is Article 4 and Article 5. Article 4 of the Code of Ethics states that realtors shall not acquire an interest in or buy or present offers from themselves, any member of their immediate families, their firms, or any member thereof, or any entities in which they have any ownership interest. So even if it is a member, a realtor, who is a member of an LLC or a corporation, an investment group, or anything that is in a group and it doesn't necessarily spell out the name of the realtor, if that realtor has any ownership interest, even if it's a minor, or anyone in their family has an interest in that LLC or corporation, then they are required to disclose. So any real property without making their true position known to the owner or the owner's agent or broker. So the first portion of this talks about in making a purchase or presenting offers. The second side of the paragraph is in selling property that they own or in which they have any interest. Realtor shall reveal their ownership or interest in writing to the purchaser or the purchaser's representative. At Realty Executives, we want to make sure that all of these disclosures are provided. On the listing side, we want to see that in the MLS report that shows that the agent is either the owner or related to the owner or somehow affiliated with the owner. On the purchase contract, we also, in our New Jersey sales contract, actually has a paragraph. I believe it's paragraph 37. I don't have the contract in front of me, but I do know that there's a paragraph in the newer contracts that provides a space where the name of the agent is required to be provided and the type of license they have, whether it is a referral license, a salesperson's, a broker's license, and that is so we're dealing with the law as well as the code of ethics. Now, when it comes to the standard of practice, Article 4 says that for the protection of all the parties, the disclosures of ownership or interest required by Article 4 shall be in writing and provided by the realtors. The most important thing here is prior to the signing of any contract. And sometimes we see in the compliance side where it's the closing date and we know that there was an ownership interest that was not disclosed, and that is so dangerous. That is one of the things that as a compliance manager makes me cringe when I see that this has not been disclosed, because this could become a real problem for the agent as well as the company. So please keep in mind that any of this ownership interest, whether on the purchase side or on the buy side, have to be disclosed prior to the signing of the contract. Now, this also applies to rentals. So when we as realtors own a property that we rent, whether it is rented through our company and listed in the multiple listing service, or we do it by owner, we also have to disclose in the listing agreement or in the MLS if it is listed, but also in the rental agreement, in the lease, that we are the owner of the property, or that our spouse or our mother or someone who is close to us, or if the property is owned in the name of an LLC or corporation, again, disclosing to that tenant that we have an ownership interest in that property. Okay, so Article 4, which is one of the reasons I decided to combine 4 and 5, is that it only has one standard of practice. However, there are a few case interpretations. Disclosure when buying on their own account. And this is a case that first came up in 1998 under Article 1, and then it was transferred to Article 4 in 1994. So what happened in this particular situation is that the client consulted with the realtor about the value of a lot which was zoned for commercial use. The client was planning to leave town and wanted to sell the property. So the realtor suggested an independent appraisal, which was arranged and which resulted in a valuation of $130,000. Now remember, this is 1988. That property right now would be worth 3 times more. But the numbers really don't matter because that changes with time, but the situation is very specific. The property was listed with the realtor at the price stated in the appraisal of $130,000. Shortly thereafter, the realtor received an offer of $122,000, which was submitted to the client, who rejected the offer. After the passage of 4 months, during which no other offers were received, the client asked the realtor if he would be willing to buy the property or the lot himself. The realtor, on his own behalf, made an offer of $118,000, which the client accepted. Months later, the client, on a return visit to the city, discovered that the realtor that he had worked with had sold the lot for $125,000 only 3 weeks after he had purchased it for $118,000. The client complained to the board of realtors, charging that the realtor had taken advantage of him, that he had sought his professional guidance and had depended on it, and that he could not understand the realtor's inability to obtain an offer for more than $122,000 during a period of 4 months, in view of his obvious ability to obtain one at $125,000 only 3 weeks later. That possibly the realtor already had the offer of $125,000 at the time that he bought the property himself for $118,000. So here's a situation where the seller has already created their own story in their mind, and of course goes to the board, and the board is going to take a look at this. Now it's going to be up to the realtor to defend their actions and show proof that that was not what happened. At the hearing, the realtor introduced several letters from prospects that had been written while the property was listed with him, all the letters expressing the opinion that the lot was overpriced. The buyer who purchased the lot for $125,000 appeared at the hearing as a witness and affirmed that he never met the realtor or had discussed the lot with him prior to the date of the purchase by the realtor. Questioning by members of the hearing panel established that the realtor had made it clear that his offer of $118,000 in response to his client's proposal was entirely on his own account. The panel concluded that since the realtor's own purchase was clearly understood by the client to be the purchase by his own account, and since the client's suspicions of duplicity were proven to be unfounded, the realtor was not found in violation of Article 4 of the Code of Ethics. So although this realtor was found not in violation, imagine the time that it took from this realtor to have to prepare, to contact all of those other potential clients, to get letters, to explain the situation, and then have to go to a hearing. This is time that it takes. So even when you win, you are still losing a lot of time. He is very fortunate that he had the ability to prove that he was not trying to work in a bad, not trying to protect his client's interest. So he was able to come out of this on the winning side. So let's go on to case interpretation number 2, which is indirect interest in a buyer. The realtor had taken 2 offers to purchase a commercial property listed with him and provided them to the owner. Both offers had been considerably below the listed price, and on the realtor's advice, the client rejected both offers. Another realtor came to the listing realtor seeking a cooperative arrangement on the listing, which was agreeable by the listing realtor. The second realtor, the buyer's agent, brought a contract from a prospective buyer, which was a bank, offering more than the previous proposals, but still 10% less than the listed price. The realtor took the offer to the client and again advised him not to accept that offer at less than full listed price. Again, the client acted on the realtor's advice, and the bank revised its offer, proposing to pay the full listing price. The offer was then accepted by the seller, and about a month after the closing, and I mean, this is kind of like the negotiations we do on a regular basis. We advise our client if we have any inkling or any idea that maybe somebody else or that same buyer might bring in a higher offer. But then here's the twister. About a month after the closing, the board of realtors received a letter from the director of the bank that had purchased the property, charging that the listing realtor and the selling realtor had unethical conduct and duplicity, which had resulted in the bank paying an excessive price for the property. So now again, somebody is making up their own story in their mind. Now, how this came about is because the complaint stated that the buyer's realtor, the agent that was working with the buyer, was a stockholder in a corporation of whose officers was a director of the bank. So there was some kind of a connection between the buyer's agent and the bank, or a stockholder that had stock in that bank. So in a transaction that was handled through the realtor and evidently used his connection with the bank to induce the bank to increase their offer higher than the market, and that neither of the two realtors had disclosed to the bank or to the other officers of the bank the connection that existed between them and the officer of the bank. At the hearing, the listing realtor defended his actions by stating that he knew nothing of any business relationship existing between the buyer's realtor and the buyer, and that he had acted wholly in accordance with the best interest of his client, the seller. The realtor that represented the buyer demonstrated that he had negotiated solely with the president of the bank, that the director of the bank, who happened to be an officer of the corporation in which he, as a realtor, held stock, was in no time contacted during the negotiations, and that the matter had never been discussed with that individual. Again, this is all, a lot of times agents get in trouble or end up in front of a hearing panel because somebody has an idea of what could have happened. And it's up to us to come and prove that that was not the case. It was the conclusion of the hearing panel that the indirect relationship between the buyer's realtor and the buyer was not of a nature to require a formal disclosure. And why? Because he never contacted that director. If he had made any contact with that director, definitely there would have been some kind of some explaining to do. And the realtor working on behalf of the buyer could not be held in violation of Article 4. The panel pointed out, however, that in a borderline case where it could be reasonably inferred that a relationship did exist, the spirit of Article 4 would be better served if disclosure were made to avoid any possibility of unfortunate or unfounded suspicions. Okay. In the third case interpretation, we have, it's called disclosure of family interest. And this is one that happens on a regular basis when we are working with family members or even very close friends. Okay. So a realtor listed the client's home and subsequently advised him to accept an offer from a buyer at less than the listed price. The client later filed a complaint against the realtor with the board, stating that the realtor had not disclosed that the buyer was the realtor's father-in-law, and that the realtor's strong urging had convinced the client to accept an offer below the listed price, that the realtor had acted more in the interest of the buyer than in the interest of the seller. At the hearing, the realtor defended his actions, stating that Article 4 of the code requires disclosure when the purchaser is a member of the realtor's immediate family, and that his father-in-law was not a member of the realtor's immediate family. And this is basically this realtor's own fault, not understanding the code of ethics and really understanding the full impact of the relationships that exist. So he's thinking, I only have to disclose if it's me, my spouse, my children, my mother, my brother. Well, the father-in-law is not his father, but is the father of his spouse. Okay? So he was very incorrect in his assumption. The realtor also demonstrated that he had presented two other offers to the client. Both were lower than his father-in-law's offer, and stated that in his opinion, the price paid by the buyer had been the fair market price. The realtor's defense was found by the hearing panel to be inadequate. The panel concluded that Article 4 forbids a realtor to acquire an interest in property listed with him unless the interest is disclosed to the seller or the seller's agent, that the possibility, even remote, of the realtor acquiring an interest in the property from his father-in-law by inheritance in the future gave the realtor a potential interest in the property. Realtor's conduct was clearly contrary to the intent of Article 4, since interest in property created through a family relationship can be closer and more tangible than through a corporate relationship, which is cited in the code. And it does have to be disclosed. The realtor was found to be in violation of Article 4 for failing to disclose that the buyer was his father-in-law. So just because there's no immediate bloodline, the fact that it was related to his spouse makes it a relationship close enough that it has to be disclosed. Now, case interpretation 4 has to do with a realtor associate. So here we have an agent who works for a company, and the person who put the complaint, in addition to including the salesperson, also included the owner of the company, the broker. So the sales associate listed a property exclusively, which was a suburban home, and subsequently convinced the seller to accept $20,000 less than the listed price. Several weeks later, the seller filed a written complaint with the board charging the sales associate with violation of Article 4, in that he had sold the property to his mother without disclosing his relationship to the client, who was the seller, and added that the price was reduced for his mother's benefit. The complaint was reviewed by the grievance committee, which, with the complainant's concurrence, also added or named the broker as an additional respondent. So now we have the salesperson and the person in charge of that salesperson, who can be either the broker of record or the manager, or both. Okay, I've seen both situations. The complaint, at the hearing, the sales associate stated that he saw nothing wrong in selling the property to his mother, and that the seller would have accepted the contract at the reduced price even if the buyer had not been his mother. The broker stated that his sales associate was an independent contractor licensed with him, that he as a realtor acknowledged that he was accountable under the code for the actions of other members of the realtor organization associated with his office, but shared that with the panel information on his firm's orientation program. He noted that he required each licensee joining his firm to complete board-sponsored code of ethics training. In addition, he required everyone in his firm to read the professionalism in real estate practice and produced a form which was signed by the sales associate stating that he had carefully read and understood his personal obligation under the code of ethics. So here, because the broker is involved now in this problem created by his salesperson, the broker now has to provide proof that he has done everything in his power to protect his office and explain the obligations of the agent to follow the code of ethics and also go through training. The panel found that the sales associate should have made his relationship to the buyer, which was his mother, unmistakably clear to the seller. He should have disclosed in writing that the buyer was his mother, so there would have been no misunderstanding. The sales associate was found to be in violation of the code, while the broker, who had made reasonable efforts to ensure that the salesperson was familiar with the code and his obligations, and that it would have been unreasonable to expect Realtor A to have known that the purchaser was the salesperson's mother. So the panel found the broker not to have violated Article 4 of the Code of Ethics. So in this situation, we have two outcomes. We have the salesperson in trouble, and we have the broker who was able to prove that he did what he could, which is provide training and information, and the salesperson did not do that. Okay. On the next one, we have fidelity to the client. The client contacted the realtor to list a vacant lot. The client said that he had heard that similar lots in the area had sold for about $50,000 and thought he should get a similar price. The realtor stressed minor disadvantages in the location and the grade of the lot, and convinced him that in the sluggish market, he should price the property at $32,500. The client agreed, and 2 weeks later, the realtor brought in an offer at the full listed price of $32,500. The client raised some questions about why did it only take 2 weeks. The realtor said basically that because they had listed it at the fair market value, the purchaser had come in quickly. 2 months later, the client discovered that the lot was no longer owned by the buyer who purchased it for $32,500, and that he had actually sold it to another party for $55,000. He investigated and found out that the buyer, the first buyer who purchased the property for $32,500, was a brother-in-law of the realtor, who was his agent. The client outlined the facts in the complaint to the Board of Realtors, charging the realtor with collusion and betrayal of a client's confidence and interests, and with failing to disclose that he was buying the property on his own behalf. At the hearing before the panel, The realtor's defense was that in his observation of real estate transactions, there can be two legitimate prices of property: the price that the seller is willing to take to liquidate his investment, and the price that a buyer is willing to pay to acquire a property. His position was that he saw no harm in bringing about a transaction to his own advantage. Oh my goodness, the nerve. In which the seller received a price that he was willing to take, and the buyer paid a price that he was willing to pay. The hearing panel found the realtor that he had deceitfully used the guise of rendering professional service to a client in acting as a speculator, that he had been unfaithful to the most basic principles of agency and allegiance to his client's interests, and that he violated not only Article 4, but also Article 1 of the Code of Ethics, which, if you remember from a couple weeks ago, is to protect and promote the interest of your client above your own. So Article 1 and Article 4, which was the disclosure of the relationship with the brother-in-law. The case interpretation that follows is disclosure of secured interest in listed property. The buyer was interested in purchasing a home listed by the realtor, but lacked the down payment. The realtor offered to lend the buyer the money for the down payment in return for a promissory note secured by a mortgage on the property. The purchase transaction subsequently was completed, but the realtor did not record the promissory note or the mortgage instrument. Within months, the buyer returned to list the property. After a few months, he listed the property for sale now with the same agent. Remember, he lent him money because he was unexpectedly being transferred to another state. So the realtor subsequently sold the property now to another purchaser, and the title search conducted by this purchaser's lender did not have the existence of the mortgage which was held by the realtor because it had not been recorded. And he also had not disclosed to this purchaser the existence of the mortgage or that debt. The proceeds of the sale enabled the buyer, the original buyer, the buyer who now is the seller, to satisfy the first mortgage on the property, and he, the realtor, agreed that he would continue to repay the realtor's loan separately. Following the closing, the realtor recorded both the promissory note and the mortgage instrument. And when the new buyer learned of this, he filed an ethics complaint alleging that the realtor had violated Article 4 by selling him a property in which he had secured a secured interest without revealing the interest to the purchaser. And of course, the hearing panel concluded that the interest of the property should have been disclosed in writing prior to the offer being made, and this agent was found to be in violation of the Code of Ethics. Now, Article 5, again, which relates in some ways to Article 4, states that realtors shall not undertake to provide professional services concerning a property or its value where they have a present or contemplated interest unless such interest is specifically disclosed to all affected parties. There is no standard of practice that applies to this because it is very clear in the article But there is one case interpretation which has to do with the appraised value of the property. So seller A and buyer, the seller and the buyer were on their own negotiating the sale of an apartment building. This is for sale by owner selling to their own buyer. But they couldn't agree on the price. They finally agreed that each one would engage an appraiser and they would accept the average of the two appraisals as the fair price. So both the seller and the buyer hired a third party who turned out to be, both of them were realtors. Because as you know, there are realtors who only do real estate, but there are some realtors who also are appraisers. And as appraisers, they have to have a separate license, but they still are members of the realtor organization and also have to abide by the code of ethics. So the seller got one appraiser, the buyer got the other appraiser, and the principals, the two appraisal reports were submitted. The principals averaged the two valuations and made the transaction at the price determined. 6 months later, though, it came to the attention of the seller that the realtor appraiser he had hired to do the appraisal for him was now the manager of the building that he had appraised on his behalf. Upon making further inquiries, he learned that the realtor, now the realtor appraiser manager of the building, had for several years been managing 5 other buildings that were owned by the buyer, and that he had been the property manager at the time he had accepted to do the appraisal for the seller. So this is a little bit complicated. It sounds like a soap opera. At this point, the seller, who now does not own the property anymore, engaged the services of another realtor to do an appraisal of the building that he had sold to the buyer. And this new valuation was approximately 30% higher than the price that they had arrived at for the purchase of the property 6 months earlier. So these facts were set out in the complaint. The complaint also charged that since the realtor was an agent of the buyer and he managed the buyer's properties, he had also become the manager for this particular property at the time that he had appraised it on behalf of the seller, that there was a connection and that he had not disclosed his relationship with the buyer at the time. He had acted unethically and in the interest of his major client and had placed his excessively low evaluation on the property in favor of the buyer. At the hearing, of course, now everybody has to appear because everybody now is a realtor. At the hearing, the seller also brought a witness who stated that he had heard that the buyer, at the time that he was purchasing the property, had told him that he had made a good buy in purchasing the seller's building because the seller's appraiser was his own property manager. The buyer, appearing as a witness for the realtor now, disputed this as and protested that he had paid a fair price. He substantiated the realtor's statement that management of his building formerly owned by the seller was never discussed before them until he had already purchased the property. It was concluded by the hearing panel that whether or not management of the building was discussed between the buyer at the time and the realtor doing the appraisal on behalf of the seller for the purchase, that had just the fact that he had uh, a contemplated interest in the property as a property manager, in view of the fact that he had served as a property manager for all other properties owned by the buyer. In view of this future contemplated interest, he was bound by Article 5 to disclose to his appraisal client, the seller, that he had failed to do that and was actually found to be in violation of the code. So I hope this has been informative for you. It's not enough to know. It's very, very important that we practice what we know, and whenever in doubt, disclose, disclose, disclose. I hope you have a fabulous Friday and a wonderful weekend, and I thank you for your time.